Hey folks, Dale Davidson here with Davidson Law Offices. I'm glad you're here today. It's a great day to have a great day. So it's kind of springtimey around here. Hot as always, and the gnats are getting thick. So let's talk a little bit about spring cleaning as far as estate planning wise. Now, we've talked about estate planning in the past. And look, estate planning is not just for the rich and famous folks. This is for everybody. So if you have any kind of assets, you really need to have the basics, okay? And so let's talk about the basics, and then let's talk about how you can clean those things up, okay? So the first one is a advance directive for healthcare or living will or whatever it may be. Now that's a document where you say that if you can't make your healthcare decisions, then you are going to appoint somebody as your agent. Okay? And then part of that is a living will that says if you are being kept alive by artificial means, that you do or do not want certain things. Maybe you don't want a ventilator, you don't want CPR, you don't want a feeding tube, you don't want an IV. Maybe it says, well, just give me pain meds and let me go. That may be your choice, okay? And then the other part of that is the pre-need declaration of guardian, that if a guardian needs to be appointed for you, that you want whoever's serving as your healthcare agent to serve. Now, from a spring cleaning perspective, what do we do here? Let's look at this. Maybe your document is 4 or 5 years old. Things have changed. Your children have gotten older, or you've maybe grown apart from whoever you've named. So look at those individuals that you've named as your agents, okay? And say, maybe I want to change. Maybe one child that you had counted on has moved to another state. So now, I think it's probably better to have a child that's close in proximity versus somebody who is 4 or 5 hours away to make your medical decisions. Because if an emergency arises, then you're going to need somebody there. But the overriding concern is, who do you trust to do the right thing for you? And who do you trust to actually be there when the chips are down, when you need them the most, okay? So look at your Georgia Advance Directive or your Florida Healthcare Power of Attorney, whatever it may be, your living will, and see if anything has changed there with respect to who do you want to be in charge. Or maybe years ago you said, well, I don't, during COVID I said, I think I do want a ventilator, but now you've rethought it and you said, no, I don't want a ventilator. It's up to you. This is a personal choice, but we want it to be your choice, not somebody else's. Okay? So the next document you got to look at is your durable power of attorney. This is, if you haven't executed one since, here in Georgia at least, I think it's July of 2017 when the law changed. If yours is older than July of 2017, you really need to get a new durable power of attorney. Okay, so it complies with all the new rules and laws and things of that nature. But again, who do you have named as your agent? Maybe you have a spouse who's since deceased. You don't necessarily have to change the power of attorney, but maybe you just want to clean it up a little bit and say, since my spouse is deceased, I want this child or that child or grandchild, whoever it may be, to be your agent and make your financial decisions if you can't make them for yourself. Again, this is a personal choice. This is up to you, okay? So choose somebody who's going to be there. Like I said, when the chips are down, choose somebody you're going to trust to pay your bills and not pay their bills. Pay their bills with your money, okay? So durable power of attorney, if it's dated July 17, preceded July 17, 2017, get a new power of attorney. Last will and testament. Now things change all the time. I mean, life is changing. We have deaths, we have divorces, we have marriages, we have grandkids, we have all of these life-changing things. We have kids who become estranged, whatever it may be. So if that has happened to you, don't delay. Okay? Go get an update to your will. It could be through an amendment called a codicil. You say, well, my husband is deceased and he was named as the executor of my will, so I want to change that because I don't want my oldest son now to be the next in line. I want my middle son because whatever the reasons are, just change it and make sure it's how you want it to be. Okay? The will is, again, your declaration to the world that when I die, this is what I want to happen with my property. This is who I want to be in charge. And I want these people to get my property, and this is how I want them to get my property. Maybe you had an unfortunate incident where a child was involved in an automobile accident, and so now they're disabled. Well, you don't want to leave an inheritance to a disabled child because that could really impact their benefits, their government benefits. So you need to have some kind of supplemental needs trust in place under your will to take care of that in those situations. Maybe you say, well, my children are all grown, and I don't want to put any kind of constraints on them, so maybe you change your will. Says when I die they get it all, period. No trust. That's simple. But again, this is your declaration to the world that this is what you want happen to your property. This is who you want to be in charge. Okay? And that's whoever would be in charge would then probate your will. Now, let's talk a little bit about bank accounts and things of that nature. Now, you go to a bank and you say, banker, I want to add my child to my bank account. Well, you've got other children too, but this child is here. Well, how is that being done? Most of the time, bankers are going to not add them as an authorized signer, but they're going to add them as a joint account holder. That happens a lot, more so than you know. And this happened just recently in a case I was involved with where the individual had about $400,000 in a bank account, put the child on there thought it was an authorized signer, but it was actually a joint account. So when they died, it went to that child to the exclusion of the other two. Now, we're having to go into court now, and it's an uphill battle, argue that there was no intent to create a joint account except for banker did that. All right, so be careful how you set up your bank accounts. Make sure your beneficiary designations are correct. If your spouse is deceased, go ahead and change the beneficiary designations on life insurance, 401ks, IRAs, whatever it may be. But just update things and keep it updated. So a little bit of spring cleaning here. Just make sure that your documents are exactly how you want them to be. Okay? And as a side note, if you have a safety deposit box at the bank, make sure somebody has access to it. A child has access to it and knows where the key is when something happens to you, because that's also a problem. Just take your documents out and look at them and see if they are exactly what you want now, because again, things change. If there's any changes you want to make, contact your attorney so they can make those changes for you. So folks, thank you for watching this little short video on kind of spring cleaning with your legal documents. Hey, check this video out. Do you need a trust, or why everybody needs a trust? That'll give you some good insights onto how you can use trust to avoid probate and do some other things as far as protecting your assets. So until next time, be blessed.